So former Massachusetts Attorney General and now of counsel at Foley Hoag, Martha Coakley joins us. She's been following this case closely with us every step of the way.
That's right. She's joining us now. Thank you so much for being with us as always.
Hi, Jessica, Ben, how are you?
We're good. So David Biedek just explained this motion to dismiss some of the charges. So what are the chances that it'll even pass?
So I think they're low. I think that the judge will have to consider this. Obviously, we want defendants always to get a fair trial, but she has a lot of options here. She has to hear from the prosecution. She could have a hearing with jurors, but notice in this motion, there's no affidavit from a juror. It's all hearsay and more hearsay. So she has to determine if it even raises a question to do that. And don't forget, defense had opportunities at the trial to ask for that. This is often the case where there's multiple defendants and multiple charges, which we didn't have here. Defense didn't ask for it at the time. And the judge also had a chance to talk with jurors before she dismissed them. So it's up to her. It always is in these instances. I think they're trying to set the stage for what may come next. You can't blame them for that, as they are aggressive advocates for their client, Karen Read.
So let's talk about that a little. So you're saying that the defense is the defense is asking that saying the judge should have polled the jury. The judge is able to do that in Massachusetts, correct? But I guess, is there a risk there? Is there a reason why they didn't ask for that at the time? If maybe some of these charges had come back and they were agreed on guilty versus not guilty?
Well, it's hard to know, but these are both experienced defense lawyers who'd figured out a strategy. And don't forget, the jury had come back a couple times before they got that blast charge, knowing there was going to be a deadlock. And so they could have asked for that, but they didn't. So this motion is a week late. It's a little bit of extraordinary help from the judge they're asking for. And don't forget, once juries either render a verdict or they are dismissed, the law favors not really interfering or going behind that unless there's a real reason that there may have been a miscarriage of justice here. So the judge has to look at it. She could wait until this goes up all on appeal, or she could deal with it perhaps by having counsel in and even perhaps considering whether she wants to talk to the jurors. But it won't be dismissed or ruled on as a result of these papers alone.
Okay, take us inside the prosecution's head now when they hear that, the defense is talking about, hey, dismissing some of these charges. How do you think this impacts them, and could this influence whether they drop any charges against her?
Sure, and I've said during the course of this that knowing where the jury was is helpful to both sides, right? So they may decide they don't want to retry the murder charge. They might have thought that anyway. It does look like some jurors were split on both sides of was it a motor vehicle homicide? That's a charge that would say she was responsible for the death and what that level was. But it gives both sides the opportunity to see, is this a case we want to talk about plea bargaining? Is this a case we want to try differently the next time we do it?
Martha, before you go quickly, I got to ask you, based on all that we now know and all that you now know about this case, if you were the prosecuting DA, would you have brought that second-degree murder charge?
So at the time it was brought and before the grand jury, I think they had significant evidence, and they believe they did, to say that she was angry enough, she did this on purpose. I think as the case progressed, we saw that was less and less likely that that's what a jury would find. But what the prosecution is looking for to find who killed John O'Keefe, regardless of what that level is. And so if they decided to drop that charge now, I think no one would think that was unwise of the prosecution to do that.
You would not be surprised. All right, Martha Coakley, thanks again for your time and expertise.
Thank you.
Always appreciate it.
Have a great night.